Hey, listeners, are you ready to take control of your car buying experience and make smart financial decisions? Introducing the Ultimate Auto Finance Guide, your go to resource for navigating the complex world of auto finance. Whether you're a first time buyer or looking to refinance, this guide has all the tips, tricks, and insider knowledge you need to secure the best deal. Don't miss out on this opportunity to empower yourself and drive away with confidence. Head over to www.ultimateautofinanceguide.com now and grab your digital copy. Trust me, it's the smartest investment you'll make before buying your next car. Welcome to Drive to Success Mastering Auto Finance. I'm your host, John Lewis, and I'm recording this episode the day after one of the most stunning courtroom developments I've ever witnessed in auto finance. It was Tuesday, November 18th, 2025, just after 2 p.m. Central Time. The Section 341 meeting of creditors for Tricolor Holdings just concluded. And I have to tell you, this is beyond anything anyone expected. This past Monday, I said Tuesday's meeting would be explosive. When I predicted that creditors would put Tricolor's executives in the hot seat with tough questions under oath, I was wrong. Not because my questions were wrong, but because the executives never showed up. That's right, more than 150 creditors, lenders, and interested parties logged on to a virtual meeting expecting to finally get answers about how $200 million disappeared, and instead, they get an empty chair. Tricolor Holdings is now officially in contempt of court, and this no-show just changed the entire trajectory of the criminal investigation. All right, let me walk you through exactly what went down at 1 p.m. Central Time yesterday in the U.S. Bankruptcy Court for Northern District of Texas, Dallas Division. Trustee Anne Burns called the Section 341 meeting of creditors to order. More than 150 participants were on the virtual call. These weren't just casual observers. These were bankers from Fifth Third Bank, J.P. Morgan, and Barclays, asset-backed securities investors, landlords owed millions in rent, equipment lenders, secured creditors with liens, and the Department of Justice, which has an active criminal investigation ongoing. Everyone on that call had one thing in common. They wanted answers. They had been waiting for this moment since September when Tricolor collapsed. Trustee Burns then made the call that would define this entire bankruptcy proceeding. Will the debtor or debtor's representatives please identify themselves? Silence. Nothing. No response. No one is claiming to represent Tricolor. No one is stepping forward to answer questions. Burns called again. Is there anyone here representing Tricolor Holdings? Still silence. According to reports from attendees and court observers, this awkwardness was palpable. People were refreshing the participant list and checking whether they'd been disconnected. Lawyers were scrambling, checking emails for last minute updates, but there was nothing. Tricolor had a no-show at their own Section 341 meeting. This wasn't a technical glitch. This wasn't miscommunication. This was a deliberate decision by Tricolor's legal counsel to tell the company executives, do not appear, do not testify. Here's what's crucial to understand. This is a direct violation of the bankruptcy code and an act of contempt of court. Section 341 of the Bankruptcy Code requires the debtor or a representative of the debtor with knowledge of the debtor's affairs to appear and submit to examination by the trustee and creditors. It's not optional, it's mandatory. By failing to appear, Tricolor has violated a federal court order. Judge Larson did not have to issue a specific order requiring appearance. The statute itself is the order. This is contempt of court, and Judge Larson now has the power to issue a bench warrant for the arrest of company executives, fine Tricolor for each day of noncompliance, revoke licenses or permits award attorney's fees to creditors, and impose sanctions that could worsen the financial position of legitimate creditors. Now, you might think, well, if the executives appear, they might have incriminated themselves. Isn't it better for them legally to not appear? Actually, no. And this is important for understanding the legal strategy here. Why appearing would have been better. If Daniel Chu or other Tricolor executives had appeared, they could have invoked the Fifth Amendment, selectively refusing to answer specific questions that might incriminate them, control the narrative on questions they could answer, demonstrated to the court that they're cooperating with the legal process, avoided contempt charges and sanctions. Yes, creditors would have gotten frustrated by the Fifth Amendment invocations, but that's legal and it happens in fraud cases all the time. So why a no-show is catastrophic. By not appearing at all, Tricolor's legal team has essentially told Judge Larson and 150 creditors, we're not cooperating. We're defying this court order. We're refusing to participate in the legal process. This creates criminal liability independent of the underlying fraud. It's obstruction. It's defiance of court orders. It's consciousness of guilt on steroids. From a creditor's perspective, a no-show is worse because it signals the company has nothing to negotiate about. They're not operating in good faith. Asset recovery is going to require litigation, not cooperation. Criminal charges are likely to come. From a criminal prosecutor's perspective, a no-show is gold. It's evidence of consciousness of guilt, active obstruction of justice, defiance of federal court authority, and conspiracy if executives coordinated with the no-show with counsel. So the legal consequences for Judge Larson has multiple options. First, issue a show of cause order. The judge can order Tricolor to appear and show cause, explain in writing why they shouldn't be held in contempt. If they don't respond, contempt findings become easier. Option 2, compel appearance by force. The judge can issue a bench warrant for company executives. They can be arrested and brought to court. They can still invoke the Fifth Amendment, but they will appear. Option 3, default judgment. By refusing to appear, Tricolor may be in default on certain claims. The court could rule against them by default, presuming all creditor allegations to be true. Option 4, maximize sanctions. Judge Larson can award attorney's fees and costs to all creditors who showed up expecting testimony and got none. That comes out of whatever assets remain for distribution. And finally, criminal referral. Judge Larson can refer the no-show and apparent obstruction to the U.S. Attorney's Office for a criminal investigation. Additional charges can be filed. Let me tell you what those 150 plus creditors showed up expecting to ask, because understanding what they didn't get to ask makes the no-show even more damaging. Question 1. When did the fraud start? Creditors wanted to know, was this a recent scheme to cover cash flow problems, or has Tricolor been systematically pledging the same collateral multiple times for years? If it's recent, maybe it's contained. If it's been going on since the beginning, that changes everything about the company's legitimacy and the criminal exposure. Question 2, who knew? Was this orchestrated by a small group of executives at the top? Was it a department-wide conspiracy? Did low-level loan officers know what they were doing was wrong? Because that determines whether we're talking about a few criminals or a criminal enterprise. Question 3, why didn't warehouse lenders catch it? Did Tricolor deliberately hide the duplicate VINs from JP Morgan, Fifth Third, and Barclays? Or were the banks so negligent in their verification that they just missed it? Because that determines whether creditors can pursue negligence claims against the lenders themselves. Question 4, where did the money go? If Tricolor was fraudulently borrowing against the same collateral multiple times. They were generating phantom cash that shouldn't have existed. Millions of dollars of phantom cash. Where did that money end up? Executive compensation, dividends to owners, offshore accounts, payments to insiders, paying off debts that shouldn't have been paid. That cash matters because the trustee can potentially claw back those payments and recover money for creditors. Question 5. What about the securitizations? Tricolor packaged loans into asset-backed securities and sold them to investors. Were those deals fraudulent too? Did Tricolor know the loans were backed by phantom collateral when they sold them the securities? Did the ratings agency and trustees receive false information? If yes, there could be massive securities fraud liability that dwarfs the original lending fraud. Question 6. What systems were in place? Did Tricolor's loan origination system have duplicate VIN controls, or was it designed to facilitate fraud? If the system had controls that were deliberately disabled, that's evidence of intentional fraud. If there are no controls at all, that would be evidence of gross negligence and reckless indifference. Either way, it matters for criminal liability. Question 7. Were there whistleblowers? Did any Tricolor employees try to report the fraud internally? Were they retaliated against? Were auditors asked about the duplicate VINs and told to ignore them? Were board members briefed on concerns and told to look the other way? This determines whether we're dealing with a corporate-wide obstruction. And finally, question 8. Who's advising you now? This is the question that would have been most revealing. By refusing to appear, Tricolor avoided naming their attorneys, advisors, and strategy. But the legal team's decision to have them no-show speaks volumes about what they believe the evidence against them shows. Now let's talk about what this no-show means for the Department of Justice criminal investigation that's already underway. This is serious. Criminal prosecutors were likely on that call yesterday listening to the no-show, and they just got handed a gift, consciousness of guilt. In criminal law, when a defendant refuses to cooperate with legal proceedings such as refusal is admissible as evidence of consciousness of guilt. Prosecutors can tell a jury, look, when subpoenaed to appear and testify, the defendant refused to appear. What does that tell you about their state of mind? Now, there are legitimate reasons not to testify, such as the Fifth Amendment protection, which is constitutional, but a complete no-show with no attempt to claim any legal protection, that's different. Now, obstruction of justice. By deliberately orchestrating a no-show at a court order proceeding, Tricolor may have just added obstruction charges to the criminal investigation. The statute is 18 U.S. Code 1503, obstruction of justice. It's a felony. It carries a sentence of up to 20 years in prison. If prosecutors can prove that Tricolor's executives have coordinated with their attorneys to avoid appearing deliberately, they could face charges not just for the fraud, but for obstruction the bankruptcy process itself. Now let's talk about cooperation with prosecutors. Here's what's going to happen next. Prosecutors will contact Tricolor's attorneys and ask some straightforward questions. Why didn't your clients appear? Who made that decision? Was it at your counsel's recommendation? The answers to those questions determines whether the attorneys themselves could face ethical violations or become targets of investigation. Smart defense attorneys would have advised a client to appear and invoke the Fifth Amendment as needed. Advising a blanket no-show to a federal court proceeding is legally risky. Leverage in plea negotiations. If criminal charges are filed, there most likely will certainly be now. The government has more leverage. Defendants facing both fraud and obstruction charges are more likely to plead guilty and cooperate. The government can threaten consecutive sentences. It's a powerful negotiating tool. So let's talk about a timeline acceleration. The no-show suggests that criminal charges are coming soon. Why else would the legal strategy be don't cooperate? That strategy only makes sense if the evidence against them is overwhelming and they're betting on some legal technicality to avoid prosecution. But now they've added obstruction to the mix, making the strategy much more challenging to defend. So what does Judge Larson do now? Let me walk you through the likely next steps. Step 1, show cause order. Within days, probably this week, Judge Larson will issue an order requiring Tricolor to show cause why they should not be held in contempt of court. Tricolor's attorneys will file a response explaining their reasoning for the no-show. They'll probably argue Fifth Amendment concerns, advice of counsel, pending criminal charges, make testimony inadvisable. None of these are ironclad excuses. The Fifth Amendment applies to specific questions, not wholesale non-appearance. And the fact that criminal charges are pending doesn't excuse you from civil bankruptcy proceedings. Step 2, compel appearance. Judge Larson will likely issue an order compelling Tricolor representatives to appear at the reconvened Section 341 meeting. This time, there might be provisions for limited scope, only non-incriminating questions, protective orders to shield testimony from criminal prosecutors, and specific topics to be covered. Tricolor can't no-show twice. Doing so would result in immediate contempt findings and potential arrest warrants. Step 3, default judgment risk. In some bankruptcy contexts, failure to cooperate can result in default judgments against the debtor. If Judge Larson determines that Tricolor's non-cooperation presents proper administration of bankruptcy, the judge can make rulings adverse to Tricolor on certain claims. Step 4, trustee discovery actions. Trustee Anne Burns can now pursue discovery under Bankruptcy Rule 2004, which allows for examination of the debtor's affairs without requiring the debtor's consent. Rule 2004 can be conducted via deposition. Tricolor can't avoid those either. They can invoke the Fifth Amendment, but they can't no-show. Step 5, advisory proceedings. Creditors can file advisory proceedings, essentially lawsuits within the bankruptcy against Tricolor and insiders for various claims: fraudulent transfer, breach of fiduciary duty, unjust enrichment, violation of securities laws. The proceedings will move forward. Discovery will happen. Depositions will be taken. The truth will come out one way or the other. Imagine you're a creditor and you've blocked time on your calendar for a month to participate in a Section 341 meeting. You've prepared questions, you briefed your legal team, you showed up at 1 p.m. Central Time finally expecting answers about your losses, and instead you get nothing. That's what happened to 150 plus creditors yesterday, and I guarantee you they're all furious. From Fifth Third Bank's perspective, they had a $200 million loss. They blocked time, they prepared, they showed up, and Tricolor's response: we're not cooperating. That tells Fifth Third that recovery will be expensive litigation and not a negotiated settlement. The bank will now pursue aggressive discovery, depositions, and litigation strategies. Fifth Third's legal team is likely already drafting motions for sanctions to recover its legal fees and costs from Tricolor's remaining assets. Now, from JP Morgan's perspective, JP Morgan had a $770 million warehouse facility with Tricolor. Their exposure is massive, and they now know this company isn't going to cooperate. We're going to have to litigate for every scrap of information. JP Morgan will coordinate with other creditors to fund the bankruptcy investigation and pursue creditor control of the process. Now, from a smaller creditor's perspective, landlords, equipment lenders, vendors, smaller creditors are watching a $1 to $10 billion bankruptcy with 25,000 plus claimants. When the biggest creditors are spending millions on litigation to recover information, the small creditors get crumbs and they know it. The no-show just told them your recovery is going to be minimal. The lawyers are going to eat whatever pie there is. Now, from a bondholder's perspective, investors who bought Tricolor asset-backed securities are now realizing that the company actively obstructed their efforts to understand the fraud. The obstruction could support securities fraud liability and other claims beyond just the underlying collateral fraud. Now, from an employee perspective, 1,000 plus employees lost their jobs when Tricolor collapsed. They're owed wages, benefits, and severance. When bankruptcy funds are distributed, employees have priority claims. But if litigation drains the remaining assets, there's less for workers to recover. The no-show just reduced the likelihood that those employees will recover whatever they're owed. All right, let's step back and talk about what happened with yesterday's no-show and what it means for the entire auto finance industry. Regulators are watching this case closely. The no-show tells them something critical. The Tricolor fraud was so pervasive, so system-wide, so deliberately concealed that company executives are willing to defy federal court orders rather than face questioning. That signals to regulators this wasn't a rogue employee, this was corporate policy. Regulators, the CFPB, state banking departments, and state attorney generals will respond with stricter examination standards, new regulations on collateral verification, enhanced audit requirements for warehouse lenders, increased scrutiny for securitization processes. Investors in the auto-backed securities saw Tricolor bonds collapse in value. They saw a $200 million fraud. They saw bankruptcy, and now they see executives actively obstructing the process and refusing to cooperate. That tells investors one thing: auto lending ABS is riskier than anyone thought. Expect yields on subprime auto ABS to rise significantly as investors demand higher compensation for risk. Higher yields mean a higher cost of capital for auto lenders. That gets passed to borrowers in the form of higher interest rates. Banks are reviewing their warehouse lending portfolios right now. Fifth Third, JP Morgan, and other warehouse lenders are asking themselves how many other Tricolor-like situations exist in our portfolio that we haven't caught. Expect warehouse lending terms to tighten immediately. Lower advance rates, more frequent collateral verification, higher interest rates on facilities, and more aggressive covenants. Some lenders may exit the space entirely. The risk-reward calculus just shifted. Every auto lender and dealer is asking, could this happen to us? The answer is only no if you have bulletproof compliance systems, automated duplicated VIN controls, daily reconciliation of loans and collateral, third-party verification of a sample of collateral monthly, segregation of duties so no single person controls the entire loan to collateral process, whistleblower hotlines and protections, and regular audits by external parties. If you don't have these in place, you're vulnerable. And if you do have them, you need to test them because Tricolor had systems and they just didn't work or were deliberately circumvented. Here's the lesson for anyone considering cutting corners. The cost of getting caught isn't just the fraud amount, it's exponentially more. Tricolor's original fraud. Quick break, folks. If you're loving the content and want to get even more insider tips on how to save money and make smarter car buying decisions, I've got just the place for you. Head over to at the Ultimate Finance Guide YouTube channel. There, you'll get expert advice and much more to help you take control of your auto financing. So do me a favor, like the videos, share them with anyone you know who's in the market for a car, and don't forget to hit the like button and subscribe and share. Join the community at the Ultimate Finance Guide and get the tools you need to drive away with confidence. Was roughly $200 million in duplicate pledges, but the costs are now the trustee administration costs of $4.8 million and counting. Legal fees for 25,000 plus creditors pursuing recovery, bankruptcy court costs, criminal investigation costs, potential damages awards, lost business value from 770 million in facility to zero, and reputational damage to everyone associated with the company. The real cost of fraud is approaching $1 billion when you include all indirect costs. All right, in the wake of yesterday's no-show and the implications it carries, here's what every auto lender and dealer needs to do this week. Here are 4 immediate actions to take. Number 1, audit your duplicate VIN controls. Review your loan origination system. Verify that duplicate VINs generate automatic flags. Confirm that duplicate pledges are impossible or generate alerts. If you find gaps, hire external IT to fix them. Number 2, reconcile loans versus collateral reports. Pull your loan origination system report. Pull your collateral reports to warehouse lenders. Reconcile them line by line. If there are discrepancies, investigate immediately. Number 3, check for pattern anomalies. Look for VINs that appear on multiple loans. Look for loans originated in rapid succession with similar details. Look for loans with the same borrowers but different VINs. This could indicate collusion or system manipulation. And number 4, notify your board/ownership. Brief them on the Tricolor case. Discuss your company's controls. Get their commitment to compliance investments. Now, here are 4 midterm actions to take for this month. Number 1, hire external auditors. Bring in Big 4 accounting firms to audit your collateral processes. Have them verify a sample of your vehicles. Have them review your loan origination system design. Get a formal audit report you can share with warehouse lenders. Number 2, revise your loan documents. Ensure loan documents include explicit representations and warranties about collateral. Include provisions allowing lenders to audit collateral. Include callback provisions if reps are breached. Number 3, strengthen segregation of duties. Ensure loan origination and collateral reporting are handled by different people. Require secondary approval for any loan to collateral match. Create an audit trail for all originations. And number 4, implement whistleblower protections. Create an anonymous hotline for reporting concerns. Establish a policy prohibiting retaliation. Make sure employees know how to report fraud concerns. And here are 2 ongoing actions. Number 1, require third-party verification. Hire external companies to verify a sample of your collateral monthly. Have them check VINs against title records. Have them verify physical vehicles exist. And number 2, stay on top of regulatory changes. Monitor CFPB guidance and regulations. Monitor state banking department requirements and attend industry conferences to learn about new best practices. Now let's talk about the criminal investigation based on yesterday's no-show. Just accelerated it significantly. Here's my timeline speculation. Based on how these cases typically proceed, I'd expect within the next 2 to 4 weeks, the grand jury would be reviewing evidence collected. The Department of Justice would be preparing indictments. The FBI would be conducting final interviews, and the no-show will be included in the evidence package. Within the next 2 to 3 months, expect criminal indictments likely. Charges could include fraud, conspiracy, wire fraud, money laundering, and obstruction of justice. Look for multiple defendants, executives, maybe some lenders slash trustees who were complicit. Now, here are the key targets. Daniel Chu, the founder slash CEO, likely charged with conspiracy and fraud. The CFO and finance leadership charged with fraud and wire fraud. Loan origination managers charged with fraud if they knowingly originated fraudulent loans. Warehouse lenders representatives possibly if they knowingly approved fraudulent collateral. And securitization trustees possibly if they knew the data was false. Now, here are some possible defense strategies to expect. We relied on our system and didn't know. Our lenders should have verified collateral. This is a disagreement between business partners, not a crime. We made reasonable business judgments that turned out badly. None of these defenses work when you have 29,000 duplicate VIN pledges and executives refuse to explain how that happened. So now expect cooperation deals. Lower level executives will likely cut cooperation deals with prosecutors. They'll flip and testify against senior management. That's why the legal team probably advised the no-show. They're already negotiating cooperation deals with prosecutors and don't know anything else on the record that could be used against their clients. So here's what I'm watching for over the next few days and weeks. This week, Judge Larson's show cause order requiring Tricolor to explain the no-show. Tricolor's legal response, which will be enlightening, any criminal grand jury activity or sealed indictments. And in the next 2 weeks, Tricolor's compelled reappearance at a reconvened Section 341 meeting. More aggressive discovery by the trustee. Sanction motions filed by creditors seeking recovery of legal fees. And then probably sometime next month, criminal indictments are likely. Asset liquidation accelerating those 11,000 vehicles sitting on lots. First major adversary proceedings filed against insiders. And then next quarter, criminal trials or guilty pleas, major settlements between creditors, new regulatory guidance from the CFPB and state authorities. So here's where we are, less than a day after the Section 341 meeting concluded. Tricolor Holdings just escalated this from a fraud case to an obstruction case. Executives who are already facing potential criminal charges for fraud now face additional charges for defiant federal court orders. The bankruptcy trustee is now forced to pursue more aggressive discovery and litigation strategies. Creditors are now forced to fund extensive legal battles to get information they should have gotten in a simple meeting. And the entire auto finance industry just learned a critical lesson. When fraud goes undetected for this long, when 29,000 loans are backed by phantom collateral, when the scam is this systematic, the company won't cooperate voluntarily. They'll defy federal courts. They'll lawyer up and fight. This means that the industry needs to implement controls today that could catch this fraud before it gets to 29,000 loans. Because the Tricolor case isn't finished, the criminal investigation is accelerating. The bankruptcy litigation is going to be extensive and protracted. The regulatory response is coming, and every auto finance professional needs to prepare for a new era of heightened scrutiny, stricter controls, and zero tolerance for anything that even smells like the Tricolor fraud. That's it for this breaking episode of Drive to Success Mastering Auto Finance. This is history unfolding in real time. I'll be monitoring the bankruptcy dockets, watching for Judge Larson's orders, tracking the criminal investigation, and bringing you updates as this case continues to develop. The auto finance just entered a new chapter. Make sure you're ready for it. Subscribe and leave us a review, or you can email me at masteringautofinance@gmail.com. I'm John Lewis. Drive safe, lend smart, verify your collateral, and never trust that the system will catch fraud for you. You'll have to catch it yourself.
jazzy beat, following that rhythm. Life's a one-way street, chasing dreams with passion. Every mile's a goal. In the world of finance, stories to be told, catching the horizon with a soulful groove, navigating numbers, got nothing to lose. Every calculation, every deal we sway. In the realm of autos, we find our way. Drive to success, we're mastering the art. Through the lanes of finance, we set apart. Jazz and soul, where the numbers align. Make your journey smooth with wisdom divine. Hit the keys of knowledge, let the insight play. From leases to purchases, every savvy way. Revving up those engines, zeros turn to ones. In the studio of life like morning sun. Feel the soul, embrace the jazz. In the auto world, let's razzmatazz. Financial gears shifting smooth and slick. In the podcast lane, we find our tricks. Cruising through the jargon, ain't no mystery. Unlocking all the secrets in auto history. Loans and rates, they glisten like the stars. Drive the distance, no matter how far.
Thanks for sticking around until the end. Before we go, if you're in the market for a new or used car or even thinking about it, you must check out Drive to Success, the ultimate auto finance guide. It's packed with strategies to help you navigate the tricky world of auto financing, avoid costly mistakes, and get the best deal possible. Head over to Amazon and grab your copy today. Just search for Drive to Success, the ultimate auto finance guide, or use the link in our show notes. Take control of your car buying experience and drive away with confidence.